My name is Jerry Clark, and I'm a resource and advocacy manager at the nonprofit TAC, Treatment Advocacy Center. This Advocacy Navigator training series is designed for care partners, family and friends who care for someone with a severe mental illness, such as schizophrenia or bipolar disorder. That's what TAC means by the term SMI. This edition of Advocacy Navigator covers civil and criminal courts. Sometimes it's confusing to family and friends when someone is arrested due to behaviors that result from untreated or undertreated SMI symptoms. It may seem obvious that the person needed care, and that's why the alleged crime happened. Perhaps there were multiple attempts to have the person hospitalized before an arrest. Unfortunately, civil and criminal courts across the country are quite siloed, and there isn't always a clear pathway from a criminal court into a civil court. This training covers the basics of these two systems. We hope this training series and other resources within our Joan C. Scott Community Resource Center are useful to you. This training series offers an overview of complex topics. We offer individualized support through our helpline if you need additional assistance. Many of the slides include QR codes, so you can easily look for additional information. A heartbreaking story that was featured in the New York Times in early 2024 is about a young man with schizophrenia who fell through every crack in the civil and criminal court systems. This man's family tried everything to get him mental health help before he became dangerously unwell. Again and again, crisis responders said he wasn't dangerous enough to meet involuntary treatment standards. He finally did something that met criteria as a crime and wasn't accepted into mental health court because his symptoms were too severe. He has anosognosia, a symptom that blocks his brain from seeing that it's ill. The mental health court explained its rejection this way. He does not agree with his diagnosis, and he does not wish to take medication. This is an example of how people are marginalized by various systems poorly built to meet their complex needs. When a court is involved, it's important to know whether it's a criminal or civil matter. If a person is arrested for an alleged crime, their case is processed in a criminal court. Charges are filed by a prosecutor, not by individual citizens, and a person has rights as a criminal defendant. The outcome of the case can be punishment. Sometimes a criminal case is diverted into a mental health treatment court. Those are still criminal courts that carry a threat of punishment, but adherence to a treatment plan can make them attractive to some defendants able to voluntarily participate. Involuntary mental health treatment, often called commitment, results from a civil court process determined by state laws. A person has due process rights, and the point is not to punish. Rarely does someone move between criminal and civil courts, although some jurisdictions have a protocol for dropping minor charges, so an evaluation for civil commitment can be considered. Conversely, a person might move from a civil process into a criminal process if they are arrested for something they do while being transported or admitted for involuntary treatment. Involuntary treatment is regulated by state laws. TAC's website provides an interactive map for looking up treatment laws state by state. Those laws govern when and how someone might be picked up on what is called an initial hold. That process leads to an emergency evaluation. The initial length of stay varies state to state and is usually between 24 hours and 5 days. If staff at the facility believe the person meets state criteria for an involuntary hospitalization, called a commitment, they must file court paperwork. A civil court judge reviews the evidence and rules on whether the person will be hospitalized for up to a certain length of time. Some states have stages for commitment, such as 14 days, 60 days, 90 days, for example. Those require a new court ruling for each length of stay. In most places, a hospital can discharge sooner at provider discretion. Nearly all states also allow for outpatient commitment, usually called assisted outpatient treatment or AOT. Some states call it MOT for mandatory outpatient treatment. During this training, I'm going to use the term AOT to refer to any program of outpatient commitment. The only states with no AOT law are Massachusetts and Connecticut. Keep in mind, though, that having a state law doesn't mean AOT is available. Many states don't have nearly enough AOT programs to utilize this less restrictive alternative to hospitalization. In places where AOT is available, it makes adherence more likely for people who struggle to connect treatment to a higher quality of life. Data show that AOT reduces hospitalizations and criminalization of illness. AOT reduces the duration of untreated psychosis and addresses significant problems caused by irregular use of antipsychotic medications, which can make them less effective across time. The QR code on this slide provides an article with more information. AOT most commonly begins at discharge from an inpatient facility. Knowing ahead of time whether AOT is available can help you bring it up when the time is right. TAC's website lists some AOT programs by state and county. If you don't find a program there, you might contact the county or a local agency that offers intensive outpatient services. Those types of agencies are the most likely to offer AOT among their services. If they don't offer AOT, they may know if it's available anywhere in the county. If AOT is available, don't assume the hospital will make a referral upon discharge. Family advocates are often the conduit for a warm handoff between inpatient and outpatient services. If AOT is not available, ask about the highest level of outpatient care possible at discharge and advocate for a warm handoff into that. Sadly, the criminal system doesn't always make sense or offer justice, but families equipped with knowledge are better positioned to funnel frustration into action. If possible, share mental health history. County jails usually contract with mental health agencies. Fax the mental health history to that agency and include a cover letter that highlights any risks for suicide or other harm, including from rapid withdrawal from antipsychotic medication if it's not provided promptly. Also share any documentation of guardianship or power of attorney. A next step is to contact the defense attorney to find out if competency is being raised. There's more about that on the next slide. If competency is established, mental health court might be an option in some jurisdictions if the person is functional enough to voluntarily participate. The QR code on this slide takes you to a Q&A list of these and other considerations as a starting point if someone with an SMI is incarcerated. If a defendant is too impaired to understand their role in the case, a defense attorney is responsible to file a petition with the court. If the judge orders a competency evaluation and the person is found unfit for trial, the case cannot proceed until the defendant is restored to competency, often with a period of stabilization in a state hospital. Keep in mind that competency restoration is not to medically restore someone. The person usually goes back to jail after being found capable of self-defense, and then the case proceeds toward a trial or a plea bargain process. Because state hospitals are under-resourced, some courts have started dismissing cases for incompetent defendants when the charges are for more minor infractions. If someone you care for has been hospitalized under competency restoration for a very long time, research what the state requires if someone is found not restorable. You may hear the term forensic used to describe any mental health services provided as part of a criminal process. If someone was harmed in the acts that led to the arrest, a victim advocate may be appointed. The victim advocate may be able to track the case and share information about hearings and motions. The advocate also might help the victim impact proceedings. For example, the prosecutor might be willing to listen if you, as a victim, request a lessening of the charges to enable mental health court or a diversion alternative. Sadly, almost 30% of family homicides and 7% of all homicides are linked to untreated or undertreated SMI. A TAC report with this data is accessible through the QR code. Your loved one has legal protections while incarcerated. The Eighth Amendment of the U.S. Constitution protects against cruel and unusual punishment, supporting an inmate's right to necessary mental health services. That's a good reason to send mental health history and share what you know about the risks if your loved one is untreated during the incarceration. Additional protection comes from the Americans with Disabilities Act, the ADA, which prohibits discrimination against individuals with disabilities, including mental illnesses. If your loved one is too impaired to understand how to use the phone or access commissary funds, for example, they have a right to the help they need to use those services that non-disabled inmates use without accommodations. Here are a few tips learned by families who have been in this place. If you communicate with your loved one in jail, ask if they've been offered a form to request mental health treatment. There's a lot of jargon in jails, and that form might be called a pink slip, a kite, a tank order, or something else. Be sure your loved one understands that they have the right to adequate health care, but they might have to ask for it. If someone in the jail is being helpful, use every opportunity to thank them for caring for your loved one while they are fragile and unwell. Outpatient providers should be contacted so they know what's happened, and some may be willing to visit or communicate with mental health providers within the jail. A jail chaplain can be an ally for family and inmates, and they aren't bound by the same privacy rules as providers. The criminalization of mental illness is far from just, even when these systems proceed as designed. Worsening the situation is a growing shortage of public defense attorneys, meaning that very unwell inmates might sit in jail for long periods of time with no action on their cases. If that's happening to someone you care for, ask to speak with a supervisor at the local public defense agency. A shortage of state beds is another big problem. Across the US, people found unfit for trial are on waiting lists for competency restoration. If that's happening, research whether there is a class action lawsuit related to competency services in the state. If your loved one is a class member, you may be able to get a disability rights organization to take an interest in their circumstances and check on them or try to advocate for a speedier process. Tax report about state beds, accessible through the QR code, provides more information on these topics. A novel approach for diverting someone out of the criminal courts and into a civil court process for involuntary treatment is being promoted by TAC. The idea is to dismiss criminal charges upon a person's civil commitment with AOT, which may happen straight from jail or after a brief hospitalization for stabilization. The short video accessible through the QR code is a place to begin learning about this unique approach. Please consider who you might share this with. I hope the information in this training is useful to you and that you will continue to learn by accessing the resources on TAC's website. Here's a reminder that you can receive individualized assistance by reaching out through our helpline. Thank you for listening and learning, and I wish you well as you navigate the complex SMI system. Keep in mind that you are doing the best you can with what you know and the possibilities available. You are not alone.